Hi, everyone. This is a brief overview of Chapter 3. I'm just going to quickly go over some of the more important amendments, particularly the Bill of Rights, which are considered to be Amendments 1 through 10. And hopefully this is just a reminder or a review for you. If you've taken Poli-Sci 1, it certainly will be. Or if you took Poli-Sci perhaps in high school, it certainly will be as well. And also, I don't know, U.S. history maybe. I don't know if they still teaching it in that. That's when I remember learning about it. So Chapter 1, or sorry, Amendment 1 is the amendment that has 4 primary rights. Of course, the one that most people could name right off the bat, which is freedom of religion, right? Freedom of religion. Most people know that one because people talk about it. They talk about how this is one of the few countries, or this is a country in which people can practice whatever religion they want. You don't have to practice a religion, but we also have the right to be free from government imposition of a religion on us. So government can impose some religion on us. The second one, of course, is the right to freedom of the press. And so we can print something or write a book, make a movie about the government that we think others should see. It may be critical of the government. It may be laudatory of the government. But we have the right to express our opinions and in print. Also the right to freedom of assembly. So we want to get together in a park with a small group of people and discuss our compliments or our criticisms of the government. We can certainly do that. Depending upon the size of the group we are meeting with, we might be required by the city that we live in, where we're holding it, to have some type of parade permit or some sort of permit to be able to have a really large group, rally permit, etc. But the whole point is that we can, in fact, have discussions with others and not have to worry about the government listening in or possibly arresting us because of what we're saying when we meet with other people. And then, of course, so I said speech, press, assembly, and religion. So those are the 4. The Second Amendment, everyone knows, especially right now with all that's going on with gun rights, gun control, and the mass shootings that we seem to have almost every week, or at least every other week, somewhere in the United States. I'm not concerned with how you feel about gun control laws, or whether you support them or oppose them at this point. At some point, I'll probably give you a discussion regarding that. But however you feel about the Second Amendment, what most people don't realize is that it wasn't until the Heller versus Washington, D.C. case that was decided by the Supreme Court in 2008, in which the Supreme Court actually said that the Second Amendment does apply to individuals, not just individuals as part of a civil militia. Up until that point in time, the court had not actually said that the Second Amendment applies to us as individuals rather than as a part of a civilian militia. The Third Amendment doesn't really apply anymore, so it's irrelevant. It's a product of its time. You'll read about it in the text. The Fourth Amendment, of course, we have the right against unreasonable search and seizures, and that's really important because it means that we can't just, if we're sitting at home one night watching TV and there's a knock on the door and the police are on the doorstep and say, hey, we were just riding around, got kind of bored, we just want to come in and search your house, can we do it? Of course they can't. Of course they can't do that. If they don't have a search warrant, they can't do it. Generally, a search warrant's needed to search your home, your car, possibly even your person. Depends on the circumstances. But of course, there are exceptions to this, and one of those is the plain view exception. And that exception is one in which if a police officer sees contraband, he or she then can proceed to search. So if you're stopped for a speeding ticket and you have an item of contraband on the passenger seat next to you, assuming there's no one there in that seat. Maybe it's an unregistered gun, maybe it's some illegal drugs. If they're in plain view, that is, the officer can see them just by leaning down and looking in your window, then the officer doesn't need a search warrant. That's called the plain view exception. There's also the fruit of the poisonous tree doctrine, and that, of course, is the doctrine that if law enforcement officials obtain evidence without a warrant illegally, and then it can be used against you in a criminal case. And that's because the U.S. Supreme Court has said in a famous case that the evidence is the fruit of the poisonous tree. So there are several other exceptions that you'll learn about when we get to the chapter on criminal law. The Fifth Amendment, also very important. Pretty much everyone knows that we have the right against self-incrimination, so we don't have to speak. If we are in custody, we don't have to answer questions. We can invoke our Fifth Amendment rights, and we don't have to say anything. And it doesn't make you look bad when you do that. It makes you look smart, by the way, because I've had students ask, well, doesn't that make you look guilty if you don't want to say anything? No, it doesn't. It makes you look smart. Hang on. Sorry about that. That was my phone. I thought I had turned it off. All right, so let's see. We also have the freedom from double jeopardy, which is the idea that we can't be tried twice for the same crime arising out of the same set of circumstances. If the initial trial ends in acquittal. Okay, so people always say you can't be charged twice for the same crime, but you can be. Of course, you can be tried twice for the same crime. Sometimes there's a hung jury or a mistrial, in which case the DA might decide to refile the case against you. Or it might be the case that you have a burglary conviction and then later on you're alleged to have committed another burglary, you have another trial and you're convicted again. It really has to be that it's arising out of the same set of circumstances and the initial trial, the first trial, ended with an acquittal. That is, you were found, they couldn't find you guilty. So that's really important because it means that the government can't come back after you've been acquitted and say, oh, hey, wait, by the way, we found new evidence. We want to try you again 10 or 15 or 20 years later, say it's a murder charge. That would be something like in the case of O.J. Simpson. If you don't know who he is, he's still alive, lives in Vegas, I've read about or heard. He was charged with the murder of his ex-wife and her friend Ronald Goldman. This was back in 1992, I believe it was. And he was acquitted by the jury. And so even if today he wrote an article or a letter to the editor, he wrote a book and he explained how he did it and said, haha, joke's on everybody, I actually did kill my ex-wife and her friend. We couldn't do anything about it. We could not do one thing about it. We couldn't retry him because that initial trial ended in an acquittal. So that, again, is really important. We also have the right to face our accusers. So people can't just say, things about us that get us in trouble, and then we get convicted on the basis of those statements. If people give testimony about us to the law enforcement officials and the DA is using it, then those people have to show up in court, right? They get served a subpoena. They have to show up. And of course, we also have a right to due process, right, to fair treatment as we go through the criminal process, and that is applying to federal cases. The Sixth Amendment is the one in which we have the right to speedy trial, and that's really good because that means we can't sit in jail for 10, 15, 20 years before we get charged. On the other hand, if you live in a large county like LA, you typically have to wait 2 to 3 years in an LA County jail if you can't post bail for your trial date. That's not uncommon. And that is constitutional. It has been challenged in court, but the court found it constitutional. That's fair and speedy given the circumstances. If you do post bail, though, you are able to, be out and about, go to work, live with your family, do everything you normally would do until you get your trial date. And so again, I think I mentioned that in one of the issues on bail reform last time. Also, we have a right to an impartial jury trial. And I often hear people say you have a right to a jury of your peers. That's not actually what the amendment says. It doesn't say anything about a jury of your peers. It just says you have a right to an impartial jury chosen from the community. And we also have a right to an attorney, and that's a really important one. Before the Miranda versus Arizona case that was decided in 1966 or 7, before then, we've always had these rights, but police officers did not have to tell us what our rights were. It was because of the Miranda versus Arizona case wherein the Supreme Court said that if having rights is meaningless if you don't know those rights, and thus stated that from that point on, law enforcement officers had to tell people what their rights were. And so a lot of people back then, before the Miranda case, didn't know they could ask to have an attorney, and even if they couldn't afford one, one has to be represented for them. The Eighth Amendment, we have the freedom from excessive bail or fines, and that's really important. If you get picked up for, I don't know, let's say attempted burglary, okay, you'll probably have to post bail on that, even if it is a first offense. It's probably going to be somewhere around $25,000 here in LA County. However, if the judge tried to impose a $150,000 bail, well, that would certainly be excessive, okay, especially when you didn't get anything in that attempted burglary. So that's really important, but also the excessive fines. We have a right from not to be fined excessively. That's important, and this is a case that was just decided last spring. It involved a young man who had been caught selling marijuana to an undercover agent. This was in a state, obviously, where it's not legal. It was his first offense, and so, of course, it's felony, though. So he entered into a plea agreement. He agreed to pay a fine. I think it was $12,000, something like that, and do community service. And, of course, be on probation for several years. So he completed everything. But then the state decided they wanted to also take his Range Rover. And it turned out he had bought a Range Rover with the life insurance proceeds that his father had left him. His father had died. He had been the beneficiary. And so he had used the money to buy himself a really nicely tricked out Range Rover. And the state wanted to take that. And he said, no, I already paid a fine. You didn't tell me you were going to take my Range Rover too. And so he filed a lawsuit against the state, and he won. The Supreme Court said that's excessive. You already imposed a fine. He paid it, and now you want to take more? Can't do it. So he got his Range Rover back. Yay for him. Let's see. And then the 14th Amendment. The 14th Amendment has the Equal Protection Clause, which states that all persons, regardless of their status, have equal protection of the laws. It has the Privileges and Immunities Clause, which states that our privileges and any immunities we have from the state abridging our rights or the federal government abridging our rights, that we have the right to be free from any laws or actions on the part of a state or a federal government that might try to abridge, or that is to obstruct, our rights and our privileges. And then, of course, there's also the Due Process Clause, and that's a very important one because this applies to the states. This says that states have to provide due process rights to someone when they're going through the criminal justice process. So all of these rights are really important. And as you move through the chapter, I hope you have an opportunity to really think about the fact that the rights that we have enumerated in the U.S. Constitution are in a lot of ways really unique and special because in a lot of other countries, even countries that are very much like us, such as Britain or Scandinavian countries, which are really good on human rights, or Italy or France or Germany, a lot of these countries don't have as many rights as we do. And if you're paying attention at all to what's going on in Hong Kong right now, people really don't have all that many rights. I hope that you will begin to recognize how much we should cherish these rights because they're not set in stone. That's for sure. The other thing to keep in mind is that while the U.S. Supreme Court may decide an issue and apply the Constitution in one way, 10 or 15 years later, they might apply the Constitution and come to a completely different decision depending upon the circumstances. And so it's important for us to remember that these rights are often being challenged. For example, a woman's right to an abortion. That comes to us from the case that was decided, Roe versus Wade, was decided on January 20th, 1973. It has been 46 years since that case was decided, and yet there are often, probably every several years, challenges to it. There are some people who believe that women should not have that right, and they would like to abolish Roe versus Wade or get the right kind of case in front of in front of the U.S. Supreme Court that would overturn Roe versus Wade. So just because a court makes a decision about a particular right doesn't mean that it can't be overturned later. So that's it for this week. I'll see you next week.